SJC-13303, Ken's Foods, Inc. v. Steadfast Insurance Company.
Okay, Attorney Green, whenever you're ready.
Good morning, and may it please the court. Lawrence Green, joined by Gregory Paonessa, representing the appellant Ken's Food. We have before this court a pure question of law as certified by the First Circuit Court of Appeals. The question is very clear. We have provided this court a roadmap firmly based upon Massachusetts law, supported by cases from sister states, supported by treatises, supported by public policy, which should lead this court to the conclusion that the answer is affirmative to the question of the First Circuit. Steadfast, in turn, the appellee, doesn't want this court to get there. They have put up roadblocks. The first part of their argument.
Could you get beyond the metaphors? Because we got to interpret this insurance policy, and I'd like you to interpret three provisions for me.
Certainly, Your Honor.
So there's provision C, then there's the emergency provision, which I'd like to talk about a little bit, which you conceded, I guess, and H. So the C covers the cleanup costs, right?
That's correct, Your Honor, and there is no dispute on that.
And by the way, and there's no issue about whether these extra costs could fit within the cleanup cost provision.
And we are not arguing that, Your Honor. These are mitigation costs. The cleanup costs were separately resolved in the federal court case.
Okay, but I want to make sure that it's clear to you, it's correct, there's no way that C covers these issues, right?
That is correct, Your Honor.
So now take me to the emergency provision, because you conceded that, and I'm not sure I understand why that's not closer to this than H. So tell me why these costs don't fit within the emergency provision.
Your Honor, our overall position in this case is based upon a common law obligation that supplements the insurance policy. We are not arguing about a particular coverage here.
But again,
and frankly, Your Honor, the question... excuse me, Your Honor, go ahead.
I mean, because this is going to be more decided on specifics than generalities. So the emergency provision is not applicable here because it's not triggered because there's not a danger of further danger of environmental contamination. Is that right? That
argument might have been made, Your Honor, but we are not relying on that.
Well, but go ahead.
Because we are, in essence, saying, and the question that has been certified before this court is, we can spend $2 million to save Steadfast $10 million, and we're not looking
I really want you to answer my questions, because one of the questions I've got is, okay, you want this common law duty extended into the suspension provision, but you're not suggesting it's implicated by the emergency provision. Why is that?
It is not implicated by the emergency provision, Your Honor, because the exact wording of the emergency provision really doesn't deal with what we were talking about here.
But the exact wording of the suspension provision doesn't deal with it either, but you say, nonetheless, we should bootstrap the common law. So again, why doesn't it apply to the emergency provision, but it would apply in the other one? Because again, from our perspective, we obviously want environmental contamination cleaned up, and the provision covered that. It also covered emergency measures on top of the provision, right?
Yes, it did, Your Honor. We are not...
You're waiving that argument, right? You're just focused on the suspension provision, and you're saying, under that, read into this particular provision the common law duty to mitigate damages.
That is correct,
That's
Your
your
Honor.
You've waived any other argument.
We were not relying on the emergency argument below.
But before you leave my point...
Yes, please, Your Honor.
Because I'm trying to understand why you would waive it there, because you clearly didn't think there was any merit to it, but you want us to do basically the same thing in the suspension provision, which actually even has more negative language because it so explicitly only references after suspension. So that's the question I want to answer before you move on.
We presented this case based upon a common law supplement to H, which was firmly founded when we filed the case before the District of Massachusetts on the Demers case, Judge Toro's case that had come out in 2009, which dealt with this issue four square. So yes, Your Honor, we placed our reliance there. We were not looking at the provision of C.
But again, and I'll stop, but, so you're saying that there was no common law addition to the emergency provision. It only applies to the suspension provision. Why? Or you just gave it up? I'm just trying to understand the logic.
The common law is very well developed on the issue that we have briefed here, Your Honor, and it relates more clearly to the suspension provision. What was done here was really to, the coverage in question was a $10 million coverage per month for suspension of operations. That was the money that was saved here. That is what was implicated here, as opposed to more emergency expenses, which is why we're talking about H.
Go ahead, Justice Wendlandt.
Thank you, Your Honor. So what Steadfast has done here is the major part of their argument, the first part of their brief, basically says, simply look at the policy, i.e. the contract. Look at that. The First Circuit roundly criticized that argument below. The First Circuit said, wait a moment, it is clear even under the Mount Vernon case that was your primary case below, that Mount Vernon looked at common law. And the First Circuit said—
Just drill on that for a minute.
Certainly.
We've looked at that. So the question is big picture. I'll get out of the minutia for 1 second. Big picture. How are you asking us to look at the common law as we look at the Mount Vernon case and think about its application here? Are you saying that the common law is going to assist in interpreting the insurance contract, or are you saying that, no, we are going to supplement the contract by infusing the common law separate and distinct from any particular
Yes.
particular part of the contract?
It's not separate and distinct, Your Honor, but what we have cited to, we all agree, there's no disagreement here, that Massachusetts recognizes the obligation to mitigate damages. Our next part of the roadmap to answer the court's question here is to say we have case after case looking at insurance policies where the court has supplemented the insurance policies.
That's based on language within the policy, correct?
And also based upon common law principles
Right,
beyond
but
that
like
language.
Mount Vernon, and I think to echo Justice Lowy, Mount Vernon dealt with the words duty to defend. And
Yes,
then-
it dealt with the
And then based upon the contract language of duty to defend, the question of Mount Vernon was whether that encompasses a counterclaim. And we looked at the all for, in for one, in for all common law doctrine, correct?
That is correct, Your Honor. We can
But
look
it
at
starts with the contract language,
that particular case did start with the contract language.
and here we don't have contract language. It's an absence
You're not
of.
relying on a specific contractual clause, but consider this, Your Honor. What if we had a situation here where Ken's simply failed to mitigate damages the day before a suspension occurred? We know that
Well,
this
Ken's
policy—
might have gone out of business.
That's true, but let me complete my point here, Your Honor. We know for
I
sure—
guess just before you go off on the policy issue, to go back to Justice Gaziano's question, which was usually, in fact, I would argue always, when you have the need to interpret a contract, which is what the policy is, you start with the words of the policy. And in the duty to defend cases, there were words in the policy about a duty to defend, and the question was, what's the scope of that? Here, you're saying the policy's words don't apply, but we should glom on this common law duty because there is a duty to mitigate damages. And so what Ken Foods has done, in effect, is save the insurer, the $10 million.
That is correct, Your Honor.
And so what is your closest analogy when somebody's trying to interpret a contract that clearly doesn't, in its plain words, apply and is not ambiguous? Do we glom on this common law duty? Because if you're relying on the Mount Vernons of the world, at least those were hooked into the duty to defend language of the contract.
Yes, Your Honor, but if we're talking about going beyond the policy, I was just positing a situation, because I believe this answers your question. If Ken's had not fully mitigated its damages before the suspension took place, we know that the contract said you have to mitigate after the suspension. You can rest assured that Steadfast would have been raising all kinds of red flags saying, we're not paying a dime for that suspension of obligations because you failed to mitigate. Steadfast would have been looking beyond the contract. They would have been looking at common law principles. What we are saying to the court is we have authority after authority from others.
Would you concede then in that hypothetical that Steadfast would have won that argument?
Steadfast would have won that argument, and Steadfast would have been not relying on the policy, Your Honor. They would have been relying on something outside of the contract. And my statement to you and to the justices of this court is we have the Demers case, District of Massachusetts, applying Massachusetts law.
That's after the loss. You keep on mentioning Judge Toro's case. That case is after the loss.
After a triggering event. After a
already
triggering,
been a
it was
law.
really during the course of a triggering event, action was taken to basically safeguard some things during the course of a fire here. So here, Your Honor, we had a triggering event. We know that there's a pollution event. And the next thing that could happen here is there's going to be potentially a suspension of operations. So unlike the Roach Brothers case where someone's removing snow before there's any risk to a roof, and they cite to Roach Brothers as their sole authority, their lead authority on the notion of the common law principle.
Well, you have the California case, too.
They had a lower court case from California, and we've argued in our brief why that is distinguishable. We have the Demers case, and we have cases from the vast majority of other jurisdictions that have considered this to say that it's only fair. And, Your Honor,
Well, no, there really aren't cases directly on point. Everyone's distinguishing everything. Can I ask you, at 251, they include a provision that says you could have bought in the record. Why is that not right?
we disagree with that, Your Honor. As argued in our brief,
I know you say that was that a CGL? Is two, I haven't read closely, but I quickly skimmed it. Is that not a pollution exclusion provision where you could buy that somewhere? Where does that come from?
what they cite to, Your Honor, is a commercial policy. As argued in our case and in the amicus case.
This is a fact question. When
Yes.
I've read 2-51, is that is a CGL provision? It's not a policy that you can add to this pollution?
It is not available in a pollution policy case. We argue that. It's argued more fully in the amicus brief.
Just because I'm going to go back to that and have to look at that. When I read 251, he's going to stand up and say, you could have bought that, and had you bought that, you would have been compensated for it, but you chose not to. And the answer to that is what? And again, focused on 2-51.
It was not available for this pollution policy, period. It was not available, and Steadfast is incorrect in saying it was available.
It's not available from Steadfast, or it's not available in the industry?
It's not available in the industry, and Steadfast has pointed to nothing on that. All they've done, Your Honor, is point to a commercial policy as opposed to a pollution policy here.
So again, when I go back and read these treatises and other things, I'm going to find that you're right, that you can't buy this kind of coverage out there?
If you can, Your Honor, we certainly don't know it from Steadfast. They haven't cited to that. And speaking of treatises, Your Honor, and I do want to make this point.
Now, I know you're going to now
This-
take
this-
us to Couch, right?
Thank you, Your Honor.
Right, okay.
And I won't quote it because it's right here on page 29 of the brief. Couch summarizes law out there, looking at the case law, stating why this is good public policy. This court has cited Couch many, many times. That's found on page 30 and on in our brief. And yes, it only makes sense for the very good reasons stated in the Couch treatise here.
Okay, so I know what Couch is. Can I ask you another set of
Certainly,
questions?
Your Honor.
So Mount Vernon makes the point about litigation, avoidance, and who bears costs. So here we've got sort of this preventive mitigation. And I understand there's a difference between the snow case where it's not about to fall, in this case where there's an ongoing emergency. But how do that line drawing is going to be difficult, right?
I don't believe it should be, Your Honor.
Okay, why not?
Clearly, the Roach Brothers snow removal case is on one side of the line. We need three things here, Your Honor. We need something very imminent to be happening here. In our case, we already had a triggering event, and there was an imminent plant closure. That's point one. Point two, the costs need to be reasonable. You just can't go out and do something exorbitant. It has to be reasonable. And three, it has to save the insurance company money. So these are three very clear tests.
The second and the third different?
The second and the third are different, Your Honor. Let's say, for example, Ken's required $11 million to avoid a plant closure. The cases would recognize you can't get more money than what you do to save Steadfast money here. So
Is that because there's you're going back to the words of the contract now?
no, I'm going back to the common law recognition here. I was just answering the question of Justice Kafker here, that what is the bright line here? It's three things. It's imminency, it's reasonable, and you have to save money. And those are very bright lines. So I will not tell the court here that we couldn't have more litigation, but that's what courts are for, and the courts ought to be able to distinguish Roach Brothers from this case.
Since you're not going to get any rebuttal time, let me ask you the question that you'd want to be able to answer on rebuttal. So assuming we can just take the common law divorce from a provision, what we're going to hear from the appellee is two things. One, that the litigation between imminent as opposed to maintenance/prevention is going to have a huge impact on how much litigation we have. And the second thing they're inevitably going to say is that we're going to completely screw up the market and the ability to price insurance. So you don't get rebuttal, so there's your opportunity to do your rebuttal.
I appreciate the question, Justice Lowy. The question that the First Circuit has raised before the court talks about imminency, to prevent imminent covered loss here. So to the extent he's going to be getting into that argument here, we're not making any case other than imminent. And there can be no question in this case where you already have a triggering event and an imminent plant loss here, plant closure. It very much was imminent. We only want the court to answer this question, and that's what the First Circuit is saying. Yeah. In terms of what's going to happen with the market and whatever here, ultimately here, Your Honor, this saves the carrier's money here. This saves the carrier's money. Steadfast in this case would have quickly had to have paid $10 million. They didn't have to pay that, and the money was saved. And what the treatise says, what the other courts from other states recognize here, is that there is a strong public policy to mitigate damages, and concomitant to that, it's to be reimbursed for the reasonable and necessary expenses of mitigation.
Can I ask one last question, Chief?
Certainly.
One last question.
So, is this a sui generis case? I mean, both sides are describing this as the sky is falling. Let me just, again, normal cleanup costs would be covered. Suspension, post-suspension would be covered. Here we've got this oddity where they're continuing their business by doing this kind of stuff that doesn't fit within all the standard provisions. Is this just a strange case, and it's not a sky is falling case? It's just the solution here is odd and unusual and creative, but it's just a weird case.
It is certainly a very fact-specific case, Your Honor, in terms of what was done here to prevent a plant closure, because these really weren't cleanup costs per se, as really costs dedicated to prevent this closure here, which may be another reason, Your Honor, to answer Justice Lowy's question, that we shouldn't be concerned about all kinds of markets opening up and some parade of horribles. I cannot represent to this court that there won't be a future Roach Brothers of the world case, but just as the Superior Court denied relief in that case, I have no fear that other courts will deny that type of what is really a frivolous case. Thank you, Your Honors.
Thank you. Okay, Attorney Dolan.
Good morning, and may it please the court, Jeffrey Dolan on behalf of the defendant appellee Steadfast Insurance Company. Several of the questions that were asked early on in Attorney Green's presentation, I think, hit the nail on the head. From our perspective, this is a case that involves two sophisticated commercial parties. They enter into a contract that has an agreed-upon allocation of risk.
Well, opposing counsel says that they had no opportunity to ever get mitigation insurance. Is that true or not true? It's important.
Yeah, it was not sold by Steadfast. I think that goes to the fact that it was undisputedly not within the allocation of risk and
What
not
about the
within.
samples? Didn't you provide sample policies?
Those are sample policy forms, just that we were able to identify from.
They didn't cover this either, did they?
They were just examples that showed that extra expense prevention, and these are types of things that are contemplated within the insurance industry. We cited pretty extensively to the discussion of this issue in the McNeil Lab case, which was the federal court case out of New Jersey.
When you sent in 251, that's a CGL policy provision, it's not a pollution, that's not something out there in the pollution.
They were, yeah, so they were commercial property policy forms.
Is that sort of, that wasn't something you sold, nor is it something available in the environmental pollution world, is that right?
Yeah, it's intended to show, because the way it would work ordinarily is that an insured such as Ken's Foods would work with their agent. There'd be a whole underwriting process where a series of forms, potentially including those forms, would be compiled to complete the policy.
But as miserable as that is, when I send my law clerk out to look at the standard forms out there in social law and insurance, are there going to be any standard forms out there purchasing this kind of stuff in the pollution insurance world?
Not in the specific pollution policy form.
So, so your argument that you could just go out and buy it is kind of a little bit misleading then, is that right?
No, I wouldn't agree with that, because you can have commercial property forms that cover things that are related to pollution. They don't necessarily all have pollution exclusions on them. They may have different endorsements that allow certain coverages in the pollution context. And these are intended to show that more broadly, as the McNeil Lab case explained, as several other cases have explained, that the way to deal with these types of coverages is to require that they be covered. But I think another point also is that even if they were...
But again, if the market doesn't provide it, again, and I don't mean to belabor this point, but it's an important point. But you can't go out and get this then. You'd have to get you have to get a CGL policy that doesn't exclude environmental harm, is that what it is?
Yeah,
and
and I
get
think-
an extra expense provision? So
Yeah.
it's not really out there in the industry. Is it or isn't it?
I think they could go out there and it would have to be a separate type of policy than what we covered to cover additional risks.
So it's not something that they didn't negotiate with you that they could have bought. It's rather they would have to go a whole different route on insurance to get this
Correct.
covered.
And what it comes down to is whether it's available in the marketplace or whether it's not. Our point is that it's clearly something that's not contemplated. When you look at our policy, it's something that's not contemplated as compared with these policies where it can be purchased in other contexts.
Are you asking us to adopt the minority rule? And if so, why shouldn't we go with the preferable public policy ruling?
No, I don't think it's a minority rule in the sense that I think a lot of the cases that are cited by Ken's Foods are in different contexts. For example, you may have a third-party liability insurance policy where you're talking about an event that's already happened, an insured, and an insurer who's responsible to pay all sums that the insured may become responsible to a third party. Whereas the Grebo case, the McNeil Lab case, and others that have addressed the issue of preventative costs in the context of a first-party insurance policy have typically come down on the side that this is not the type of thing that can be assessed under the common law.
I have trouble with that because this isn't like the Roach Brothers case, because there is a triggering event. In fact, C is triggered, right? So we're not dealing with an abstraction or even a third-party liability. There's first-party liability here under C. It's just how we deal with the relationship between C and H, right?
Right. So under C, I think what's important to clarify under C is that it's the cleanup costs, and as you mentioned earlier, it is the emergency costs as well. All of those were paid to the tune of more than $1 million. Those have been paid, they've been subject to a release, and they've been dismissed with prejudice in the underlying case. So that is not and cannot be how Ken's Foods gets the coverage here. And our point is that that is the allocation of risk. If they wished to put it within anything that we had paid for, or that they had paid for, or coverage that they had purchased from us, that would be a different question. But what they're asking the court to do in this case is something different. What they're asking the court to do is say, we've resolved everything under the policy. Steadfast has paid us more than $1 million in coverage. We've agreed to dismiss all claims under the policy. They've waived them here, and they've dismissed them with prejudice. But what we're saying is that under the common law, you should look to doctrines of fairness or public policy and impose a different result than what we bought.
But how do you deal with their hypothetical, which is that if they hadn't done this, you'd be looking at $8 million more, and you'd be arguing that they didn't mitigate their risk as they're required. So how do you address that? And also, why isn't there some logic to that?
Well, I think I'll answer the first question first, I guess, is that, well, I guess I'll answer this, maybe I'll switch that around, answer the second question first, because the McNeil Lab case that I referenced earlier actually had a pretty good explanation of this. And what they said is that these arguments do have some superficial appeal. But when you get down to the legal analysis, and we block quoted most of the relevant language of McNeil Lab in our brief, and what they said is really when you get down to the legal analysis, it doesn't work as a matter of law. First is, and there's a couple of reasons. First is that it misframes the issue, because as I mentioned, what they're arguing in this case is, wouldn't it be more fair to have a different result than what we bought? Or wouldn't that be a better result for everyone? And that under Massachusetts law is not a grounds for disregarding the policy. Secondarily, the notion that this creates disincentives or an inappropriate incentive structure is incorrect, especially in the first-party insurance context, because as was mentioned, in the real world, if you're talking about a first-party insurance policy, you're dealing with the insured's own business and their own property. You're not dealing with their liability to a third party. So they have their own incentives to protect their own business and their own insured. They have competitive repercussions. They may go out of business if they just elect to shut down in order to recover insurance. It may impact their personal relationships in the industry with customers, with business partners, with whoever else it may be. In this particular case, Ken's Foods has alleged that some of those costs related to compliance with state regulators. They're not in a position where they can just ignore state regulators to manipulate the insurance coverage. And if you expand the precedent that they're asking for, it would actually apply on a broader basis to potentially, say, an insured who lets damage happen that may subject themselves to civil or criminal liability if they were to let a fire happen, or if they were to let something happen that would potentially put other parties in danger. So there are other incentives at work here as opposed to it just being
I get
about
there are
the
other
money.
incentives and they want to keep in business, but don't you, what's your answer? We asked your brother, does Steadfast win this case? If they hadn't mitigated, so you're saying you couldn't use that argument that they didn't mitigate?
But it would be dictated by the policy, which is consistent with our position in the entire case. So if they had shut down.
So again, so if they had not done this, you wouldn't be able to argue that their duty to mitigate is only post-suspension, it's not pre-suspension, And so I just want to hold,
Yeah,
so when we
okay.
write that into this decision, and you're the responsible for that, the industry is going to like that?
Well, it goes to what's covered once there is a suspension of operations, which is not the cost that you incur to keep your business up and running. It's the income that you lose. So in either case, it would not be as if once you get to the shutdown, you then get
But they made a different argument. They're saying that they would have argued, had we not done this, that we didn't mitigate. So I'm going to, again, you get to write our decision for us. We're going to have that footnote in there. How do we address their argument? Counsel for the insurance company says, nope, they didn't have a duty to mitigate. You want that in the opinion?
No, well, no one is disputing that the duty to mitigate exists under the law. What we're saying is that the way the duty to mitigate would come in if they had a suspension of operations would be to address the amount of recoverable compensation that they could receive if that were to occur. It does not require any corresponding obligation to repay costs that are incurred to keep their business up and running. It would just, what they would be entitled to would be some sort of loss of business income, which is subject to the ordinary and the contractual duty to mitigate, and the amount of recovery may be impacted, but it would not be a scenario where it would be an independent
Can I
exclusion
ask
to
you a
coverage.
different question? And it sort of dovetails off of what Justice Kafker is asking you, which is, if they did not avoid the suspension, would you, the insurer, have, by incurring these $2 million in costs, if they did not avoid it, what would you be arguing instead? If
So if
they
they-
just let the shutdown happen, even though they could have avoided it for $2 million, what would be your argument under the policy?
Again, it would be the same argument, that they would get the amount of lost business income that they sustain that is necessary as a result of the suspension.
Even though they could have avoided altogether the closure?
Well, that would go to the amount of recoverable, in the sense that it's subject to, you can't just close unless you have to, right? That it's a necessary closure, suspension of operations.
Right, and that would have been your argument, that
Yes, and it
they
would-
allowed themselves to close even though they could have avoided the closure. So it wouldn't have been like, I paid $10 million, here you go, here's your check. You would have had an argument under the policy.
Correct.
That they, eyes wide open, allowed themselves to close even though they could have avoided it.
And we would have been dealing within the four corners of the policy and the
Right.
application of the policy, rather than these untethered
So
concepts.
when we're
of
talking about
risk.
duty to mitigate, not mitigate, you're talking about post-suspension. And I think the more appropriate argument that you would have been making, had they not incurred, would have been they had a duty to avoid the closure.
Yeah, or they could have been able to or to open back up within
A shorter period
a
of
short
time.
period of time. That, and I would also note too that the numbers that are being thrown around, just procedurally, I want to make sure that I'm on the record with this, that the issue before you was addressed at an early summary judgment motion in the underlying case. So there never was any discovery as to the notion that they spent $2 million to save $10 million. I want to make sure that my silence is not acceptance of those numbers. Those are not numbers that have been litigated. Those are their allegations.
I think we're aware of the scope of our certification.
Okay, yeah, I just wanted to make sure that I'm not waiving any right to dispute what the
Talk to the
numbers.
First Circuit about that.
Okay.
Can I just make sure, I want to make sure I understand what you just said to Justice Wendlandt. You would be arguing, had they just stood back and let it happen, you wouldn't be arguing you shouldn't have sat back and let it happen.
Well, that would go to the amount of, it would just go back, it would revert back to the policy if they had allowed that to happen.
Because the policy says you have to mitigate once.
Once you suspend, correct? If they actually had to suspend their operations as a result of this because they didn't do this, then it would go to the amount of recovery that was available under the contract.
So under the contract, they're not obligated to do anything until the triggering event, and then they are required to mitigate.
And correspondingly, correct, and we're correspondingly not obligated to reimburse them for the costs if they do
Because
the
So
that's
they
their job.
mitigated too early. Is that it?
No, I don't think that's
Under
right,
the
because
contract.
The contract?
yeah, and I think it goes back to and it's the High Plains beef case that we cited in our brief. It's a federal court case from Kansas, kind of explained this issue. that an insured is not prejudiced if they're able to continue their operations because the coverage that they purchased never applied in the first place. And they say that expressly in the case, that if you're able to continue your operations, even if it's at a reduced capacity, you're not prejudiced because your insurance company doesn't pay you because what you did purchase was never triggered to begin with. And that is, again, we're dealing with a lot of persuasive authority, I recognize, because there has been no Massachusetts appellate case that's addressed it, but I think that case has a good explanation of why that is. And again, as I mentioned, the McNeil Lab case.
So it's that gap that we're dealing with. Again, they contracted for cleanup costs. They contracted for emergency expenses necessary to prevent environmental damage, substantial environmental damage. What they didn't contract for is this sort of extra work they had to do to keep in business.
Right, and that's...
Because they did, again, they had to establish the necessity of, as you explained to Justice Well, the necessity of ceasing operations. But that, there's a gap out there, and they couldn't buy insurance for it either, because you didn't sell it and nobody else does. But there's this gap that's out there, then you say that we leave to the market.
Right, but it's undisputedly not part of what they purchased from us, is at the end of the day.
But they couldn't purchase it. It's this kind of, and I'm not saying
No,
it's...
that I would agree with they couldn't, because there have been cases, the McNeil Lab case that we cited, I think was 1986. One of the cases that they cite was the Coal City case from back in 1956. That had language that, so even if it hasn't been litigated in this precise context, several cases and several ISO forms and several other things have addressed this on a policy basis. And the important thing is that under Massachusetts law, it's important to enforce the insurance contract pursuant to the risk that the parties agree to cover. And that if an insurance company is obligated to pay costs on grounds of public policy or fairness, that's not something that they ever underwrote. And it would undermine the predictability, the stability that undermines the entire, or that underlies, the entire insurance industry, because that's the fundamental function of insurance, is to underwrite certain risks, enter into a policy that accurately reflects the risk, and accept a premium that also accurately reflects the risk. And I know I'm a little bit late on time, and I'll just make one last point, I guess, in that regard, is that it's not just the insurance industry, that it's other industries that rely upon the certainty of enforcement of contracts and allocations of risk as they're written, whether it's construction and additional insured and indemnity issues, whether it's banking, whether it's finance, that the predictability and enforcement of contracts has broader implications than just the narrow facts of this case, and both within the insurance industry that would have to price in not just the particular cost that we're talking about here, but the unpredictability that the court may decide that other costs are consistent with public policy, other than just mitigation costs, and that they may have to factor in those costs into their underwriting process, which would result in extraordinary increases in premiums across the Commonwealth. So again, I recognize that I'm over time, so if you have any other questions, I'm happy to answer them, but otherwise, we would rest on our briefs.